Welcome to Rise Maximum Radio, and let's say special thank you to Melissa for giving us the 10 a.m. news headlines, as well as to AD for that morning synergy. I am with you guys, EJ Nav, and together with the professor. And we have in studios today two representatives of the Public Defender's Department, and it's Mr. Shazvon Ramdas.
Yes.
And Miss Michelle Ali. Good morning to you guys. How are you today?
Good morning. We are fine, thanks.
Nice, nice.
Good morning.
The professor.
Good morning. Good morning, everyone.
So we have some very, very intriguing questions to deal with this morning. But first, tell us about your department. You know, what is the Public Defender's Department, and how does it relate to the prison service?
Okay, sure. So we are from the Public Defender's Department. Our department came on board in the year 2020. Basically, what we do is provide efficient representation for persons who have criminal matters before the courts. With regards to our service to the prison itself, we would represent persons who are unable to privately retain an attorney. It's a simple process by way of applying through a standard form to get a public defender to represent anyone's interests. It can be someone who has an ongoing matter before the High Court, or someone who is awaiting the filing of their indictment. Our department would certainly represent that person. And of course, with a JIPA coming on board, our department also represents persons who fall in that category.
Very nice. Very interesting.
One question though. You must be incarcerated to retain a public defender.
Well, as of now, we only do matters at the High Court level. If it is that you are on bail, then of course you can visit one of our offices and sign up for a public defender to represent your interests. So it doesn't mean that you have to be incarcerated, but it certainly will be that you have to have a matter ongoing in the criminal assizes, in the JIPA courts, or you are awaiting the filing of your indictment.
I heard you said AJIPA earlier, and you just said it as well. So the Administration of Justice, is it?
Yes, it is.
And it was proclaimed by the president in December of last year. So can you give us more insight on this act, and how will it help the inmates, who are incarcerated at this moment?
Yes, sure. Mr. Ramdas, but perhaps
Yes, thank you. Thank you. Good morning, listeners. So before I get into AJIPA, I think it's important to understand the system before in terms of preliminary inquiries. So the starting point is that AJIPA applies to indictable matters only. So summary matters still stay at the magistrate's court. So if somebody is charged with an indictable matter it would start at the magistrate's court, and then the magistrate would deal with that matter until there is a preliminary inquiry hearing or an inquiry, and then the magistrate, after hearing the evidence, will determine whether or not whether there's sufficient evidence for the matter to go to the High Court. Now, the difference with that is that with AJIPA, there are now two stages before a matter is sent to the High Court. The first is called the initial hearing, and the second is called the sufficiency hearing. So indictable matters now start at the High Court as opposed to the magistrate's court. So masters now deal with indictable matters. Now, when the matter is brought before the master, the first stage, as I said before, is the initial hearing. So at the initial hearing, the purpose of that hearing is for the master to issue something called a scheduling order. Now, the scheduling order lists out certain directions that the prosecutor, the police, and the defense must comply with before the sufficiency hearing. And these directions relate to disclosure of witness statements and evidence that the prosecutor intends to rely on at the sufficiency hearing. Now, at the sufficiency hearing the master is tasked with determining whether or not there is sufficient evidence for the matter to go to the High Court. Now, there's no oral evidence being led. There's no cross-examination. The master only considers the witness statements and the evidence on the paper. Now, the purpose of a JIPA is to streamline the pre-hearing procedure to ensure that it's faster and reduce the wait time. And another key feature with a JIPA matters as well is that before the indictment would be filed at the end of the preliminary inquiry. So what we'd have is inmates waiting a couple of years after the matter is completed at the magistrate's court, waiting for that indictment to be filed. But now the indictment is filed before the sufficiency hearing. So that scheduling order also includes a direction for the DPP to file the indictment. So it's hoped that the sufficiency hearing would reduce the backlog by reducing the wait time for persons to have their day in court.
Okay, very, very interesting. I did not understand that part. Let me ask a question pertaining to what you said about the sufficiency hearing. As you said just now, there are two hearings, basically, initial hearing and the sufficiency hearing. How long can we expect a sufficiency hearing to last?
Okay, so let me just clarify something about the initial hearings and the sufficiency hearing. So it's a stage. So it's not two hearings, but it's two stages. So what you would see is that the initial hearing may actually occur over a series of different hearings. So you may have an adjournment for the initial hearing, but that doesn't mean that the next second hearing is a sufficiency hearing. The second hearing may also be an initial hearing. So the initial hearing is complete when the master grants the scheduling order. Upon that order being granted, the next stage is now sufficiency hearing. Now, in terms of the time it would take, it depends on two things: whether or not, first of all, the master's list, and secondly, if that person is on bail or not. If the person is on bail and the master needs to adjourn the initial hearing, there is some latitude in terms of the time because the person is not incarcerated. However, if the person is incarcerated, the adjournment should be within 28 days.
Okay, interesting. But so what you are saying is that, let's say someone gets charged for capital now, they go in front of the masters, they have an initial hearing, and let's say they get 5 months adjournment after this initial hearing, the first hearing, initial hearing. They got a 5-month adjournment. When they go back after that 5 months, they can have another initial hearing.
No. So it actually it depends, right? So if the master issues the scheduling order at that stage, that 5 months later is the sufficiency hearing. If there is no scheduling order, it should actually be 28 days because a person on bail, a person charged for murder would not be able to access bail unless they apply to a judge.
Okay.
All right. So I guess it all entails the length or the time frame where that particular matter needs to be researched or just reviewed, so to speak.
Yes, certainly so. It will also depend on the complexity of the matter as well, and of course the master's docket and availability.
To probably.
Okay.
Certainly
One
so.
other thing there, you were saying that when they start the sufficiency hearing is when the indictment will be filed?
The indictment is to be filed before the sufficiency hearing starts. So with the scheduling order, there is also a direction for the DPP upon receiving the witness statements to file the indictment.
Okay, so should the matter continue? They committed to go in front of a judge now. After the sufficiency hearing, they already have the indictment. Do have that process to wait on the DPP again?
Yes.
Okay.
Yeah, so that is the aim of a JIPA, and that's the hope, so that once the sufficiency hearing is concluded, there's a very short, or at least a shorter wait time for that matter to be before a judge, because the indictment would have already been filed.
Okay, but let's say at that stage now, let's say they have to go in front of a judge. Could they, if they want to probably finish with the matters at a faster period, seeing that the indictment is already there, could they say, let's say, ask for a plea in front of the masters?
Of course they can. Actually, plea discussions can start as early as being a suspect. So you can enter into plea discussions or plea bargaining with the DPP as early as being a suspect in the police station. So basically, if it is that this person is before the master in the initial hearing, he can opt to enter into plea discussions as early as that stage. If he wants to wait until the filing of his indictment, then he can, and at that stage stage where the matter is being transferred to the judge, he can engage in plea discussions, and that also raises the issue of the MSI. Once it's a non-capital matter, and if it is that he wishes to apply for a maximum sentence indication, which is the MSI, he can file for it because there we will have him already having his indictment filed.
And let's say if it's a capital matter.
If it's a capital matter, then the procedure for a capital matter, well, probably I should start at the beginning. The penalty for murder is death. So it's the maximum and the minimum. You can't plead to murder and expect to get a range of years. You have to get a lesser basis to that charge in order to enter into any kind of plea discussions if you want to get a range of years. Of course, that applies for adults only. If it is that at the time of the commission of the offense, the person was a minor, then by a lot of changes that took place, the Children's Act, international standards, and so on, a range of years is usually considered by the court. But let's talk about adults being charged for capital matters. Basically, they have to get a lesser basis before they can plead, and the only person that can grant that lesser basis after, of course, the request made by the attorney is the Director of Public Prosecutions. There's no one else that can grant that lesser basis. So once that lesser basis is granted, then an adult who is charged for a capital offense can enter into plea negotiations or file for a maximum sentence indication.
So here we are hearing that the Administration of Justice Indictable Proceedings Act is actually fastening the system.
Well, so
to some
far,
extent.
that has been the result. So far, we, the public defenders, we have seen it to work the way it's supposed to work. Of course, it's a new act and it's a new procedure, so we don't know what will come up along the way. But so far, as the act aim to fasten the preliminary inquiry system and all of these things, it is doing
It's
what
working.
it's supposed to do. Yes,
that's a
indeed
good
so.
thing.
Yes. One more question on the act. At the initial hearing, can a master grant the accused bail?
Yes, so the master bail is something to be considered by the master, but with the exception would be for murder. Because only a judge can grant bail for murder.
Right.
For all other offenses, yes, the master is empowered to grant bail.
Okay, so I understand. So should they be in front of master, they still have to apply to the judge for bail.
For capital offenses,
capital
yes. In
offenses.
fact, it's under the Act, it's required for the master to consider bail at the initial hearing.
Okay.
I understand. Good.
All right. So another question is, if there are several inconsistencies in a person's matter, can the lawyer file for a no-case submission even if they are awaiting trial?
Okay, so when you mention the word inconsistency, this is something that is usually fleshed out at a trial.
Right.
So inconsistencies are what makes a prima facie case in the first place, and a
Right.
prima facie case is what needs to be made out for the magistrate, as the old procedure was for the magistrate to send the matter to the High Court. And
Okay.
inconsistencies are, well,
They have to iron it
inconsistencies,
out
the nature
to
of
make
it,
sure.
correct, is for
Okay.
the finder of the fact, which is the jury or the judge, to decide on. So inconsistencies is something that needs to be fleshed out at a trial. Now, in terms of a no-case submission, a no-case submission is usually filed on two occasions: at the end of the preliminary inquiry or at the end of the sufficiency hearing, now with a JIPA, once there isn't enough or sufficient evidence to form a case against the person. The attorney can file a no-case submission at that point in time for the consideration of the master, or at a trial hearing when the state presents its case. Should the evidence be insufficient to mount a charge, then the attorney can file a no-case submission at that point in hope for the judge to uphold same and thereby dismiss the matter.
Very simple.
Yes, I think the reason why that was asked, at the end of every preliminary hearing, people would go through the notes now or go through what the witnesses said or so on and so on, according to what was used in the court there, and they would see a lot of inconsistencies, and this is the reason I think this was asked. But really, you all cleared up that a lot, because that's
Yes.
something is like we are hearing so much inconsistencies, and why have they committed this matter to the High Court?
Yes.
But as you say, yes.
And the inconsistencies all come down for the fact finder to decide on, which is the jury
Yes.
or now or the judge.
Yes.
All right. I think you were like touching on this a short while ago, but here it is. If there's a lot of inmates who are currently awaiting an indictment from the DPP, right? And some they apply for MSI, which in many matters is a lengthy process, as we know. They want to know if they can go before a master, for case management to decide if their case is murder or manslaughter or whatever the case may be. So, can you tell us more about that?
Well, that is actually a compounded question because it touches and concerns a couple of issues.
Okay.
Or while someone is waiting for the filing of their indictment, it means that the only audience they really have before the court would be the fast-track court hearing.
Right.
This is where they would have filed a notice of intention to plead guilty.
Right.
And because they intending to plead guilty, the court tries to fast-track the filing of that indictment in the interest of justice in that manner. So basically, that is the only audience they will have until the indictment is actually filed. And only when the indictment is filed, then they would be able to go before a master to get that audience to deal with certain things. Now, the reason why I said it's a compounded question is because the issue of plea and pleading on the whole, that is a discussion to be had with the accused attorney and thereafter with the DPP before they go before the master. As I said earlier, the only person to engage in these plea discussions with or give a lesser basis to the charge is the director of public prosecution. So the master, all in all, will do the case management of the matter, of course. However, they would not be the one to discuss any plea or anything like that. Plea discussions are usually without prejudice, meaning that the parties would discuss that. That doesn't come before the court at all unless we come to
That is what
an
you call
agreement.
plea bargaining.
Yes.
And what's the difference with plea bargaining and MSI?
So,
Yes.
Mr.
So
Lucas.
an MSI is a maximum sentence indication.
Right.
And this is an indication from the judge or the magistrate for summary matters of what is the likely sentence if the accused is to plead guilty at this stage of the proceeding. So it is the maximum sentence indication. So this indication does not consider the mitigating factors of the accused. It does not consider the discount for a guilty plea, and it also does not consider the time spent in custody. So the maximum sentence indication, it can go down, but it can never go up.
Okay.
So the MSI procedure is initiated by the accused applying to the judge. The accused applies before the court for an MSI, and an agreed facts must be prepared, and the judge considers the agreed facts as well as the criminal record of the accused. And it's on that basis the judge gives an indication of what the likely sentence or the maximum indication what it would be. Now, the difference between the MSI and plea discussions is where the accused bargains with the prosecutor. So you don't need permission from the court to engage in plea discussions. You need permission from the director of public prosecutions. And in these plea bargaining, as Ms. Ali would have highlighted earlier, it can start from the time you are a suspect in a matter. And with plea bargaining, what the prosecutor and the accused can agree to a particular course of action, which could include a plea to a lesser count, a starting point for a sentence, a final sentence, or even a sentencing range that should be appropriate in that case. So after the DPP gives permission to engage in plea discussions, and let's say the parties come to an agreement, that agreement must be filed within the court. Now, once that's filed in court, the judge now reviews the agreement, and he has the power to either disregard the agreement or to accept the agreement. For example, if it is that two parties agree to a starting point, the accused and the prosecutor. And the judge feels like this starting point is too low. He has the power to increase the starting point.
Okay.
And from that stage, we can get into the other factors of the other stages of sentencing, considering the mitigating factors of the accused, the guilty plea, the discount for the guilty plea, and the time served. So the key difference between the MSI and the plea discussions is who is it starting before? One is the court with the MSI, and with the plea discussions with the DPP, with the prosecutor. Yes.
Okay, one question concerning the MSI there. Someone who applies for the MSI, can they do, will the judge do the MSI without the person having an indictment, or they have to have an indictment first?
So, in order to even be before the judge, an indictment have to be filed. So, an indictment in the case of a MSI have to be filed first. As Mr. Ramdas mentioned, a MSI can take place in a magistrate's court as well. So, a magistrate can conduct a MSI hearing as well. And one key element of the MSI for capital matters in particular, because I know that there are a lot of persons who would say to me, Miss Ali, I sign up for the MSI and I'm not getting the MSI, but they are charged for a capital matter. Then I will go on to explain it isn't automatic. For a capital matter, the DPP must accept a lesser count, a lesser basis to murder before we can proceed to ask in the court for a maximum sentence indication. If you go before a judge and ask for a maximum sentence indication on the charge of murder, and this is for adults only, the judge has hands are tied. He have to say the death penalty because that is the maximum or the minimum. So he have to get a lesser. In terms of someone who at the time of the commission of the offense was a minor, he can apply for MSI on the charge of murder.
Right.
And there the judge will consider a sentence in range because, as I mentioned before, there are things in place to protect the minor who committed the offense, such as the Children's Act, such as international standards, and so on. Life sentences, will the death penalty being off the table for minors who committed capital matters.
Okay. As you said just now, a lot of people say I sign up for the MSI and nothing is happening, or we are not going before the judge. That's hence the reason for asking the question. But even a lot of guys on the inside, I remember back some years ago when the MSI came out, when we had the opportunity to go to the High Court in Port of Spain, a lot of people would go down for MSI hearing, but they did not have an indictment. So it was like we was just wasting time, basically transport and the court's time, because you are going to get an MSI hearing, you are going in front of the judge, but you don't have an indictment. So I guess that's where you said the straighten it out. Basically, you have to have an indictment before you go for an MSI hearing now.
Yes, and further to that, with the establishment of the Public Defender's Department, what we do now is basically we represent the interest of all persons who are on that list. Basically, persons who are on that list, we represent their interest by having a visit with them, speaking with them, seeing the preliminary documents such as their committal bundle. That is everything that took place in the magistrate's court, and we assess whether they have a lesser basis so that we doing background work before the filing of the indictment. So and we actually send letters regarding plea discussions at that point as well. So upon the filing of the indictment, then we engage the court in the DPP with plea discussions or the court with an MSI.
Okay, one more question there. Let's say somebody on the inside there know, how would they start to apply for MSI or plea bargain? But that's one of the questions on the inside basically. How do we go about asking for MSI or plea bargain?
So basically with regards to the MSI, once it's a non-capital indictable offense, then it depends whether the person indictment is filed or not. If the indictment isn't filed, then the Public Defender's Department will still represent their interest. If it is that the indictment is filed and they are actively before a court, if they have representation, it's a matter of speaking with their attorney, filing the application for the MSI, or speaking with their attorney, giving instructions to engage in plea discussions with the DPP. with regards to the Public Defender's Department, we usually do something called Form 9 visits every week, where we see persons who places their name on a list with the Welfare Department to get
Okay.
representation, to get advice, and so on. So we actually see persons on a weekly basis from all the prisons across the country, and if someone is interested in getting legal advice or representation, they can opt to put their name on that list through the Welfare Department, and a representative from our department will certainly visit them. Yes.
That's very good. So it doesn't mean that the person's family or basically person's families have to contact you, or they can have them.
No, they don't have
Through the
to.
welfare
If
department.
through the welfare, or the family can come to one of our offices and basically make the request.
Alright.
If the person, isn't incarcerated, then he or she can come to one of our offices as well and make the request.
Very interesting.
So maybe we can take a little quick break and come back, because we just have a few minutes again before we wrap things up. So,
Okay, sure.
so guys, with us is Mr. Ramdas and Miss Ali of the Public Defender's Department, and they're here to advise you guys on some questions that you may have, that you may maybe consider asking. So feel free to jot down what you would like to ask, and we're definitely gonna pose these questions to the Public Defender's Department, who will be here and sure to set your mind at ease. So keep it locked. It's Rise Maximum Radio, radio for change.
It's Rise. Maximum Radio. Maximum Radio.
We are here with the Public Defender's Department for this segment, and asking Mr. Ramdas and Miss Ali for some, insight, some advice, and some knowledge more on the public defenders, what they do, and how can they help in getting justice served as swiftly and efficiently, and without any prejudice. So we have the professor.
Okay, so this is the last question. How many cases are currently awaiting trial? Can you, if I go into the other part, probably for this?
Yes. So that is a difficult question to answer. Unfortunately, we don't have the statistics at this time. We know it's a lot. We could acknowledge it's a lot, and Ms. Ali would go into the changes that we are seeing because it's a lot of cases. But unfortunately, we don't have the statistics.
Okay, I understand. We discussed the MSI and the plea bargain before, right? And we knew that basically the MSI and the plea bargain came about to help with the backlog and so on. Why is it in some matters will the DPP not accept the plea? Accept a plea? Because a lot of people, they want to have go through a plea bargain and so on, or even the MSI with the judge or with the DPP and so on.
Yes.
Why it is he would not accept the plea?
Yes, certainly. So basically, we see this happening time and time again, and it all comes down to what the evidence is in the case. So in order for the DPP to reject a plea, it is more times than less that it is the request for a lesser basis to the murder. And if it is that a lesser basis does not arise from the evidence, then the DPP cannot give you the lesser basis. And that lesser basis is either felony murder or manslaughter. If the elements of the offense of murder is made out on the state's case and there's no room for the DPP to give a lesser basis, he has no choice. He will, in those circumstances, refuse the request for the lesser basis. And that is the only in that event is the only time we see rejection of a plea. If someone wants to plea outrightly to an indictable offense, being a non-capital matter, then it is usually just a procedure of getting the DPP's permission to plead to the indictable offense, and then basically either agreeing sentence with him or agreeing sentence asking the court to pass sentence.
But let's say the person is here 17 years, 15 years, 19 years in some instances.
Yes.
How fair is it really to the person that after these number of years to already be put on a trial, because according to our constitution, if I'm right, we are for a fair and speedy trial, basically.
Of course, and
But according to what is happening, it's not speedy.
well, of course, and that is a backlog that has been occurring within the judiciary and the criminal justice system on the whole, and all stakeholders are currently putting things in place. The Public Defender's Department
Right.
coming on board, a JIPA coming on board, the judiciary hiring new judges to sit and hear
Yes.
matters, different. They are trying different things with the docketing of
To speed it
matters
up and to
to speed
improve
it
it.
up. So all stakeholders are currently trying to speed up the downfall in the criminal justice system. Now, persons who are here 17 years, 19 years incarcerated awaiting a trial, it's simply just unfortunate. And basically, we, the Public Defender's Department, we certainly prioritize matters like that with regards to providing efficient representation, seeing all the avenues that person can explore, as well as now with the new docket system within the court. This only came about a week ago, Mr. Ramdas?
Okay.
About a week ago, where there are certain judges dealing with more vintage matters. There are certain judges dealing with now only sexual offences matters, and so on. So the docket is a little bit different in to achieve the
to
goal
help.
of, yes, of course,
So
alleviating
we can
those
expect to see things
deficiencies.
moving a little faster.
Well,
if
we
it
would
works.
hope as well. We
Yes,
would
we will,
certainly
yes.
hope as well.
In most instances, let's say someone here who is here 15, 17, 19 years and so on, after these number of years, they haven't had a trial in the past before that, and here they are going to have one now. Is it really feasible for the state to put them on a trial? Costs, one, probably availability of the witnesses and so on. Even some of the officers in the cases, they have moved on or for whatever reason. So is it really, you understand? I don't think.
Well, at the end of the day, that's a decision for the Director of Public
Sure.
Prosecution
Process
to
has to be
make.
going through.
And basically, we see they are usually officers of the court as well. If it is that in some cases, witnesses are just unavailable and so on, evidence isn't readily available and whatnot. The Director of Public Prosecution
Considers.
exercises his discretion with regards to cases like that.
Oh.
Yes.
Well, I guess that wraps it up.
One more.
One more.
Would the Director of Public Prosecution, do you think he would accept a plea in the interests of justice?
We certainly saw it happen before, but it really, really have to be in the interest of justice, as well as if it's a capital matter, there must be a lesser basis. But the interest of justice argument is always used in most of our pleas where it's a tricky one. The
to
evidence
justify
is a
your
little, yes. And in the interest of justice, the Director of Public Prosecution does, consider the acceptance of pleas.
So there's some of the ways that we can consider asking for a plea, because in some instances when you write for a plea and you don't get through, it's very frustrating in some instances.
Yes, but if the evidence doesn't reveal that lesser basis, it is just that is the evidence in the
I
case.
understand.
Yes.
So very interesting discussion for today, Mr.
Yes,
Ali.
guys, and of course, I hope that some of your concerns were dealt with by Mr. Ramdas and Miss Ali. And always remember that you can send us your questions, your concerns, your queries, and we would definitely send these questions to the Chief Public Defender.
Yes.
And the Chief Public Defender will then send people like Miss Ali and Mr. Ramdas to, help you right at R.I.S.E Maximum Radio. So let me say thank you very much to Mr. Ramdas and Miss Ali
Thank you all
for
for
taking the
having us.
time, and of course, on behalf of us to the Chief Public Defender, thank you for being very supportive in this forum, as well as to you, the listeners. Thank you for being so interested in this segment at R.I.S.E Maximum Radio.